afternoon and welcome to our webinar. We are going to be discussing today the recent Constitutional Court judgment dealing with the circumstances in which you can move across from a tax dispute process to the High Court. And that's generally by way of requesting a review or a declarator. In the, I think, quite famous words of Judge Sutherland in the ABSA case, you avoid the long and protracted slog to the tax court. This issue generally arises, or almost always arises, in the context of Section 105 of the Tax Administration Act. So that section was introduced in 2012, and when it came in, it provided an election essentially for a taxpayer to decide whether to proceed via the tax court or via the High Court. Then the trouble all started when it was amended in 2015 to state that you have to stay in the tax court process unless a High Court otherwise directs. So a taxpayer could only go to the High Court if it got a direction from the High Court that was permissible. As I said, this arises generally in the context of reviews and declarators. So there are a couple of different types of reviews. The main one is the Promotion of Administrative Justice Act, so a PAJA review. And there's also a legality review. So a review under PAJA basically looks at or challenges a decision saying that the relevant considerations that should have been considered were not considered, and irrelevant considerations were considered. And a legality review is more review on the basis that the decision maker acted outside of their powers. A declarator is something that deals with a pure question of law on which a court is asked to adjudicate. And I think it's important to point out that reviews and declarators deal with issues of law and not with fact, and we'll come on to that later on in the presentation. So there was a whole raft of cases that went up through the courts and ended up in the SCA. And the theme that arose in the SCA was that you can only approach, or Section 105 only applies where there are exceptional circumstances. So you can only approach the High Court for review or declarator where there are exceptional circumstances. One of those judgments was Rupper Resources, and Ponen's judgment talked very much around exceptional circumstances. And the question then arises, well, if that's so, what are exceptional circumstances? So firstly, is that the correct test? And secondly, if it is, what constitute exceptional circumstances? So 5 taxpayers ended up going together to the Constitutional Court in respect of this matter around Section 105 and exceptional circumstances, and when you can approach the High Court as opposed to staying in the tax court process. And that judgment landed with something of a thud, being 150 pages long. 31st of March, I think it was handed down. So Andries, Myburgh, and Simon Weber are going to be taking us through the principles established by that case. I don't know if there's anyone in the country, I don't think there's anyone in the country who knows more about this area of tax dispute law than Andries. And he and Simon were involved in the UMK, which was one of the judgments in the Constitutional Court. And then Andries, along with Andries Giles, was also representing the taxpayer in the Leuven Metals, which is one of the other cases dealt with in the Constitutional Court. So they are going to be talking to us about the judgment. And if you've got any questions, if you can just post them into the Q&A box. And if we have time at the end, we will then chat through those. So Andries and Simon, over to you guys.
Great stuff. Thank you, Peter, and good afternoon, everyone. So just by way of some background, as Peter said, we acted for United Manganese of Kalahari, or UMK, who after receiving adverse transfer pricing assessments in 2020, decided to launch an application for review relief and also for a declarator. The review relief was premised on SARS's non-compliance with Section 42 of the Tax Administration Act during the audit. And the declarator was on the meaning of the term managed or controlled in the definition of connected persons in the Income Tax Act. So, Andries, do you maybe want to give more context around those prayers?
Yeah, so obviously, as a transfer pricing matter, one of the key ingredients for those provisions of the income tax to apply is that the parties that is party to this transaction must be so-called connected persons. So if they are not connected persons, then those provisions do not apply. Now, there was a whole process of the audit. SARS came up and they issued a letter of findings, and they say UMK is a connected person in relation to two parties to which it has the transaction on a certain basis. That was due, well, first we asked SARS to clarify the factual and legal basis, which they did, and then it was duly responded to show to SARS that they are not connected. Because remember, the whole purpose of Section 42, and that is quite important, and that's something which is missing in this Constitutional Court judgment. The whole purpose of Section 42 is to avoid an assessment. There's case law that confirms that. So that is to avoid the matter going through, as Peter said it, the protected slog through the tax court. So SARS is supposed to consider your response to letter findings duly, and they have done that on the first ground, on the first basis, or the first thesis, as the court has set out. But then when they issue the assessment, it was a completely different basis, which they say UMK is connected. And they haven't given the taxpayer the opportunity to respond to that, and therefore to avoid an assessment. So that was the issue there, to say, while there was procedural unfairness, you should have given us as a general rule of aria alteram partem, in terms of read of Section 33 of the Constitution, but as codified in Section 42, an opportunity to respond to that to avoid an assessment. Because remember, once an assessment there, it's pay now, argue later. Then SARS is in the pound seats, because unless they suspend the full amount, which they never do, they sit with all the cash. So that puts any taxpayer on the back foot whenever they go through the tax court process, whether objection and appeal, and potentially to settle matters. Because hardly ever SARS will, if you settle an amount less than an amount that was paid based on the unsuspended portion of your pay now, argue later principle. But more importantly, so secondly, we said, well, SARS say UMK is connected because its immediate offshore shareholder, which owns 49% of its shares and has 50% voting rights, to the exclusion of the board of UMK and the management, and the other 50% shareholder was managing and controlling UMK. And by virtue of that, is connected. And they say, well, what that means is not the actual management, the control is merely the ability to influence. So that was the issue. On the Leffen one was on the declarator, on purely on a statutory interpretation matter. On Section 11(1)(f), it's in the gold industry when gold is supplied to a SARB, Minco, and to a bank. Andries Giles was the person who drove that process. And there was also an audit. There was a letter of findings that was responded to the letter of findings, but immediately a notice was given to take that on an application for a declarator, i.e. on the meaning of that phrase or parts of that phrase. So those were the matters there. And I think what is quite important if we go through it is that generally, the audit process where you respond, especially a letter of findings, to respond to avoid an assessment. Otherwise, it's pay now, argue later.
Yeah, and so the High Court dismissed UMK's application. It wasn't on the merits of the review or the declarator. It was based on the conclusion that UMK did not apply for a directive in terms of 105, which was incorrect. Unfortunately, the Supreme Court of Appeal also came to the conclusion that UMK did not apply for a directive, and that then prompted our client's application for leave to appeal to the Constitutional Court. When we were in the Constitutional, applied for leave to appeal, I think Forge Packaging had already submitted his application. Ours was followed by Rapper Resources, then Lewin, and then APSA. APSA was quite late to the party, and one of the questions that arose there is whether APSA had in fact abandoned or preempted its right of appeal, but the court ultimately found that there were grounds to overlook any preemption. Now, the way that
I think APSA was lucky there in the sense that if they did it on their own, they probably would have failed on the preemption ground. But because all the other parties were there before the court, I think the court said, well, you are now here, the other parties here, so we'll oversee the preemption and we'll entertain your application for leave to appeal. And they were, fortunately, Dane and Lieven were one of the 5 that actually survived the 105 jurisdiction issue, and then will now be heard on the merits, which is, I guess, good.
Yeah. So the way that the judgment is written is the approach is that the court distills several principles around that sort of relate to Section 105, and then it applies those principles to each of the 5 cases. So as Andries has mentioned, the judgment only deals with the aspect of Section 105. The cases that were successful on 105, Lewin and APSA, they will return to the Constitutional Court to argue the merits in those cases. So if we look at the principles distilled, the court addressed several questions, and these being whether 105 applies to both review and declaratory applications, what is the effect of 105 on the High Court's jurisdiction, when and how the question of a 105 direction should be adjudicated, what is the applicable test, what is the position where there is no assessment yet, what is the nature of that power, and then the court gives relevant factors to the exercise of what it calls the 105 power.
Yeah, Simon, maybe before you address those, maybe people will ask, but why if you're busy in an audit with SARS, if they issue a notice of audit, provide request for relevant material, responding those, why would you even consider approaching the High Court for a review or declarator? Now, I think that's probably a relevant question, and a good question is that, our approach is always with clients is that from the moment you get a notification of audit, you and the request for help, you'll probably get a sense on what SARS is going to audit. And when you supply information, and eventually when you get your letter of audit findings, you will pretty much see that what are the issues and what SARS's view. So as Peter in the introduction mentioned, whenever you approach the High Court for a declarator and a review, that is on notice of motion. What does that mean? So it's unlike a tax court trial where you go through the court and you call witnesses, factual expert, you do discovery, etc., and all of those things. That's a protracted slog, which I think Judge Sutherland refers to. Application is quite neatly. It's by application, and you add affidavits, a founding affidavit, and if SARS opposes the answering affidavit, and then you reply. And that is both your evidence and your pleading. So in any event, if there's a dispute of fact, forget about Section 105, a High Court, due to its inherent discretion, and will not entertain an application if there is a dispute of fact. So obviously you will only approach the High Court on application, whether it's a review, if there's no dispute of fact. So as part of the tax court dispute process, we will assist clients to respond meticulously to queries by SARS and to crystallize if there are issues in dispute. It's only questions of law. Try to limit your dispute of facts. I don't think you'll be able to eliminate it altogether, but in certain instances you can. And then you will say, well, if this is clearly a statutory interpretation issue, then maybe one should consider approaching the High Court for a declarator rather than to go through respond to letter findings, SARS, is not convinced, finalize issue assessment, pay now, argue later, objection, disallow objection, notice of appeal, exchange pleadings, do discovery, call witnesses, factual or legal expert, etc. And whoever loses there has an automatic right of appeal either to the full bench of the High Court or the SCA, and these days even after that to the Constitutional Court. So if it is a peer point to law and you can crystallize the matter, it's always good from the outset to sit with clients to say, what is our possible remedies and how's our strategy in dealing with this audit if it actually results in a dispute? So that's why, as an arsenal of things, you always consider alternative remedies, and that's what reviews and declarators are.
Yeah, and as the Constitutional Court has now confirmed, Section 105 applies to both review and declaratory applications. We, on behalf of UMK, we certainly made the point that a declarator is not an invasive remedy. It's not really an attack on an assessment, but the court rejected that argument and said that in substance, it is an attack on an assessment, because as soon as a taxpayer obtains a favorable declarator, it will either use that declarator to force SARS to withdraw an assessment, or it will use that to bind the tax court if there are underlying proceedings ongoing in that court. On the effect on the High Court's jurisdiction, it's some clever wording used here by the court. It says that although the High Court has a pre-existing jurisdiction, it cannot exercise that jurisdiction until it has issued a directive in terms of 105 of the Tax Administration Act. And for that reason also, which was really what the fight was about in Rapper's case, is that SARS is not compelled to provide the record in terms of Rule 53 or Uniform Rule 53 until the court has issued a directive in terms of 105. So a Rule 53 record is usually obtained in review proceedings. And in this, it's a record of the decision and how the decision was made and how the administrator, or SARS in this instance, came to the conclusion which is impugned.
Yeah, just on that, I think Judge Rogers also used the words conditionally suspense, because there was quite a long debate in the court in the day. How does one interpret unless a High Court otherwise directs? Is that an ouster of the jurisdiction? And that's why I think the court entertained the appeals, because it both impact on a taxpayer's right to just and fair administration, which is Section 33, and the right to access to courts, which is Section 34 of the Constitution. So, as Simon has mentioned, the High Court has inherent jurisdiction. I mean, as far back as I think is in when was that? The Metcash case. I think that was in 2020, where the Constitutional Court says in tax matters, the High Court always has jurisdiction in tax matters if it relates to questions of law, whether it's a review or a declarator, and whether there's an assessment or not. Obviously, 105 has now limited that. And I think it was Judge Majid that raised the question to one of the counsel to say, but he's quite surprised that none of these taxpayers has taken on Section 105 on the basis that it's unconstitutional, because it is, whether it's a limited or a conditional or a temporary ouster, an ouster is an ouster. So that was the debate. So I think that's why, and the counsel said, well, we think we can interpret Section 105 to avoid unconstitutionality. And I think all of them argue that in the circuit, especially declarators, you're not attacking assessment per se. So 105 shouldn't be coming into play at all for declarators, whether there's an assessment or not. And the reviews sometimes same, even if there is an assessment and you attack SARS's process on procedural unfairness grounds, you're not per se attacking the assessment. So that was the debate there. And I think Judge Rogers has come out to say, well, if there is an assessment, whether it's a review or declarator, 105 conditionally suspends the High Court jurisdiction, and you will have to ask for a directive. And I think all of the taxpayers in this matter, I can't remember whether maybe Forge has, but UMK, Leefin, APSA, I don't think Rapa has, but They've asked actually for 105 directions as part of the note and made out cases for that. So that is always important to make out a case in any event. So I think that's why it's important to understand the context of 105. So who knows, maybe some taxpayer feature may take on the constitutionality of 105 altogether, even on the basis, say, conditionally suspends it. It is, whether it's a ouster, a conditional or temporary ouster is an ouster. So we'll have to see in future.
Yeah. And the court further said that the issue of 105 should be considered as a threshold issue at the outset. So that doesn't necessarily mean separate applications. I mean, if you file your founding affidavit in the High Court, that is something that needs to be addressed there. It's only in the cases where there might be a fight about the Uniform Rule 53 record that there might need to be a preliminary hearing on this aspect specifically. But otherwise, it will be dealt with together with the merits of the actual application.
Yeah. Let's maybe use an example. If one do get an assessment, you ask for suspension of payment. SARS comes back and they don't suspend, or only partially suspends payment pending your objection and appeal. That decision not to suspend or only partially suspend, in our view, is not subject to objection and appeal. So your only remedy, apart maybe asking SARS in terms of Section 9 of the tax that reconsider their decision, is to approach the High Court on the review, to review and change or substitute or refer it back to SARS on their decision not to suspend. There's no objection and appeal on that, but yet there is an assessment. And then the question is, well, if you bring such a review application, you obviously want our SARS to give their record of their decision as to why they haven't suspended full payment pending your objection and appeal. Because sometimes the monies can be large. And as I said in the outset, once you pay something to SARS, it puts the taxpayer on the back foot in its process, even if you go through the tax court, if you at some stage want to settle it. Because whatever you've paid to SARS, I haven't seen SARS actually paying money back. So if you want to do a settlement, they probably will settle on something not less than the amount that you've paid based on the suspension. So that's why I think it's important there to get a Rule 53 record. But there you have to then, from the outset, make out the case to say, give me a direction in terms of 105 and set it out. So you have to fully, put that out there. In your notice of motion, you must ask for it and make a case out in your founding affidavit. So that's one example where that potentially could apply, even if you go through the tax court process.
On the test, when a direction is sought, and this is quite important, and I think quite a big win for taxpayers, is that the Constitutional Court rejected the exceptional circumstances test, which I think originated in Judge Sutherland's judgment in APSA in the High Court, but it was then sort of expanded by the Supreme Court of Appeal in RAPA and UMK. And it, like I said, the court rejected to say that it's not, the test is not one of exceptional circumstances. There's nothing in the text or context that requires such a test of exceptionality, but the test is rather whether there's good cause to bypass the tax court, and whether it's appropriate in the totality of circumstances for that application to be heard by the High Court.
I think that's quite an important bit, because the debate always was, is it exceptional is there a test? And if so, what is the test? So I think this is quite what is 100% clear for us all that came out of this judgment. Whether or in what circumstances and factors, particularly for reviews, I think is still a bit unclear, although the court gives guidance. And for declarators, it's quite clear. If there's an assessment, yes, you have to prove it and you have to show why it's appropriate, even though a declarator per se doesn't attack an assessment.
Yeah, and as Andries has alluded to now, the court also then confirmed that Section 105 is not directly applicable where there is no assessment yet. But the court says that it's the review and declarators are still discretionary, so a court can still refuse to grant that relief in the circumstances. The court further said,
Sorry, yeah, carry on.
the court says it may still be inappropriate to hear that application if an adverse assessment is expected, but the taxpayer is jumping the gun to avoid the application of 105. So I guess
It's a fine line there, I guess, Simon, is that when SARS starts, for example, an audit, notification of audit, and taxpayer can see that SARS is go a certain direction, and the planning is then to if it's a pure question of law, to get it to a pure question of law is to limit the facts. That there's no factual dispute there, and ask the question and then launch your application. And particularly, I can't think about on any case where you will approach a court on review, but I mean, that's what APSA did. They did it on the basis of a review, basis on error of law. But also, typically you would do a declarator on the statutory interpretation. And I think that's what Lieven did. Before it got an assessment, it actually launched that application for a declarator. And also we had the other case fairly recently, late last year, through an audit, we could clearly SARS said in their considered view, this is the legal interpretation. So again, when they issued the letter of findings, that's what they say. So clearly their mind were made up. And the question then is, well, should we then approach? There was no dispute of facts. The facts were sort of common cause. And it was purely stated. And the tax in question, if there was an assessment, is 1.2 billion. So you can just imagine if you do your response to the letter of findings, SARS already said, well, in their considered view, so whatever you're going to say, they're not going to change. And you probably won't say anything different in your response than you already did when you respond to their request for relevant material. But if they issue an assessment, it's pay now, okay later, 1.2 billion rand, and you ask for suspension, they probably won't suspend. And then we sit with counsel, we say, well, this is appropriate case to ask the court for a declarator. And that's what we did. SARS obviously opposed it through RAPA and UMK1 and the SCA in our faces. But we clearly made out the case. SARS opposed it, but when the time came when to file their answering affidavit, they were late. So we then applied for the court to put it on an unopposed roll. That is what you can do if they oppose it and they don't file. So we put pressure on SARS. And when we came close to the date, they approached the taxpayer and we agreed. They agreed they will concede to an order. And we got an order in the court confirming the interpretation which the taxpayer said. And there was other issues in dispute there as well. But that was particularly in this particular issue. So again, that's an example where one can sit with taxpayers and, when you get a notification or audit, respond to that carefully. And from the outset, plan your strategy in going forward. Otherwise, the taxpayer would have got an assessment, 1.2 billion in tax, asked for suspension, most probably wouldn't get a suspension, a full suspension, if any, and then you have to bring that on the review, and then you have to 105 jurisdiction issue, and then you, in the meantime, have to file your objection, all of those things. So there, clearly, SARS would have gone all the way to the tax court, and there we managed with the client to avoid that. So that is a critical example of where reviews and declarators, as part of your tools in your dispute resolution process, if you manage that well and carefully, could be quite useful.
Yeah, definitely. So on the nature of the 105 power, the court said that this is a true discretion as opposed to a broad one. And this is quite an important consideration because it means that essentially once the High Court has either decided to grant a 105 direction or refuse to grant it, an appellate court, the Supreme Court of Appeal or the Constitutional Court can only interfere with that decision in very limited circumstances. So I think in my view, this means that you sort of only really have one shot, and that is when you are in the High Court to convince the court that you are entitled to a 105 directive.
Yes.
The court then goes on to outline relevant factors in three broad categories. So the first one is general factors that sort of cut through reviews and declarators. Then it gives relevant factors in the context of reviews, and then lastly in the context of declaratory orders. On the relevant factors, the Constitutional Court said that there is no hard and fast rules about how the court should exercise its discretion in granting a directive in terms of 105, and that the totality of circumstances need to be considered in each case. What the court then confirms is that, which is quite interesting and a development, is that whether an objection has been lodged and disallowed, is a big consideration in this, because in the context of reviews, that is an internal remedy for purposes of PAJA. And generally,
Yes.
in terms of PAJA, there is a duty on the applicant to exhaust those internal remedies before proceeding to the High Court with a review application. In that context, it said that although there's no duty to exhaust internal remedies when it comes to applications for declarators, that is still a relevant consideration, because the applicant would need to show SARS why it should be excused from that and be entitled to go directly to the High Court. Then a recurring theme in the judgment is what the court calls a powerful factor, and that is the aversion to piecemeal litigation. So what that essentially means, and how the court explains it, is to say that if a taxpayer pursues certain grounds in the High Court and other grounds in the tax court, that creates the risk of piecemeal litigation, because the tax court proceedings would need to be held in abeyance, while the specific point is then litigated through the High Court in review and also a declarator. And it's only when that process then goes through possible appeals that it goes back to the tax court. So there's obviously that risk there of piecemeal litigation.
Yeah. So I think it's important as part of your planning how to deal with your disputes with SARS. As I said from the outset, consider the various stages. And I think once you have an assessment, you have to object to it. And once SARS has disallowed the objection, the court says that is an internal remedy. However, the appeal to the tax court is not an internal remedy, because why? It's a court that look at it afresh. It's not SARS officials, so objection goes back to the SARS officials and they consider it. So that's why an objection is an internal remedy, and it's quite important for a taxpayer to follow that. But one must always remember that once you got an outcome of objection and it disallow your objection, you have to file a notice of appeal to the tax court within the prescribed period. Otherwise, your assessment becomes final in terms of Section 100. And once your assessment has become final, it may impact you on your review or declarator High Court application. So that's something to be mindful there. And what we've done in those instances is, once we got it out, we filed a notice of appeal, and in the notice of appeal, we put in a request there that the matter is put in abeyance pending either your review or declarator. So that's what we done in one matter, which we won in the High Court on a statutory interpretation as a declarator, and which SARS has now appealed to the Supreme Court of Appeal. So that objection has been done, has been disallowed, and that was purely a question of statutory interpretation. So that tax court appeal process is on hold, pending the final outcome now in the SEA and possibly the CC, depends.
On the relevant factors in the case, in review cases, the court broadly distinguishes between conduct preceding an assessment and then the merits or the validity of an assessment, which is one of the very interesting aspects of this judgment, is the court's assumption. So the court says it does not make a final pronunciation on this, but it assumes that non-compliance with Section 42 cannot be a separate ground of appeal in the tax court. So, for instance, as Andries explained at the beginning, in UMK's case, the non-compliance with Section 42, that is not something that can be a separate ground of appeal when that goes to the tax court. So, but the court says, even so, the procedural, that doesn't necessarily mean that an application for review to the High Court is necessary, because procedural unfairness can be cured. And then the question there is whether the curative remedy of the tax court proceeding should be given preference to a High Court review remedy. And what the court essentially means by this curing aspect is to say that even if there was procedural issues during the audit, those will be cured by going to the tax court, because the tax court hears the matter afresh and it ultimately gets to the right answer on the merits. So it doesn't really matter that there might have been procedural irregularities during the audit. And that is what is meant by this curing remedy of the tax court.
Yeah, I think if you go through the judgment, you will see that the court looked at how these type of matters are dealt with, I think specifically in New Zealand and in the English courts or the English legislation. And then particularly a lot of the review parts, which the court pronounced, and I think they sort of obtained from two Supreme Court of Appeal, Canadian Supreme Court of Appeal judgments, which dealt, and I think this one of the concepts that came from that is this: the tax court process could be a curative remedy. What does that mean? As Simon said, is that, well, my example, Section 42, the purpose is to avoid an assessment so that you don't have to go to the tax court in a protracted slog and pay now and argue later. But the court said, well, you know, if you respond there and SARS don't, or they don't, you still have a chance when you do your objection. If SARS then still disallow that, you again have a chance when you go to the tax court, because the tax court hear it afresh. So through the process, your procedural unfairness can be cured. But I think what the Constitutional Court, and repeating myself, hasn't dealt with, I think the big difference is that once you have an assessment, it's pay now, argue later. And that put taxpayers, in my view, on the back foot. That's where a High Court review and potentially declarator could avoid that whole process. But I think there's some, the court hasn't pronounced very clear terms, particularly on the reviews. You will see in the judgment they refer, I have not been addressed on this issue, and therefore I assume the following, and I carry on assuming the following. So I think particularly on the reviews, there's still a gray area in a lot of the areas. So I think, yes, I think what is good, we know if you have an assessment, you must ask for a direction, and the test is not exceptional. So that is at least clear. So, but the factors itself is fluid. So I think one has to assess it on a case-by-case basis.
Yeah, and then on the relevant factors in the context of declaratory application, the court says that yes, if it raises a pure point of law, then it would be appropriate for declaratory order. But even so, the taxpayer might have to show something more, either that there might be public utility or general importance in that declarator. So meaning that it would be useful for other taxpayers to also have clarity on that specific point. Or for instance, it will apply to years of assessment beyond those that are currently in dispute. That
forms part of your whole notice of motion, and particularly your founding affidavit, where you make out your case for the 105 declarator directive.
Another interesting observation by the court was it said that normally when you go to the tax court, costs are not awarded to the to the winning party. So SARS shouldn't be really expected to be out of pocket if you take an application to the High Court. So if the applicant then forgoes a request for costs in the circumstances, then that could be something that favors the granting of a 105 directive. And then again, I mean, a point which is made repeatedly throughout the judgment is the risk of piecemeal litigation. What the court essentially says here is that the point of law that you wish to pursue in a declaratory application must be the only basis upon which the taxpayer disputes the assessment. Although the court doesn't use these words, essentially it means that it must be dispositive of the matter. And I think that's why, perhaps definitely why Lewin was successful, also, and why the court might later on consider the merits of that application. So if we then look at how these principles were applied to the 5 cases, so like we've said at the beginning, UMK's case was a review based on non-compliance with Section 42 of the Tax Administration Act, and also a declaration on the meaning of managed and controlled in the context of the connected persons definition. So the court here confirmed, I mean, this was, UMK definitely did apply for a directive in terms of 105. So the Constitutional Court said that both the High Court and the SCA erred in finding that UMK did not seek a directive. And it then fell upon the Constitutional Court to decide whether in the circumstances UMK had made out a case to obtain these directives. It said that in the review, even though UMK had a plausible case for review, and that essentially that UMK had reason to be aggrieved in the way that SARS conducted the audit, that non-compliance will be cured. So there is no need to entertain the review application, and on that basis, it was not prepared to issue a 105 declaration for that review prayer.
But again, there the issue is obviously, if you get an assessment, it's pay now, argue later. And obviously, so UMK did apply for a suspension. It was not fully suspended, as normally the case. But to avoid further litigation, they decided not to take that decision, not to fully suspend on the review to the High Court. But yeah, that is the big difference. The issue is that if you can convince us to avoid an assessment by virtue of Section 42, that would be preferable. And they did do so on the first basis. So I say they connected. And we can all speculate now, and the court says yes, but the objection was done and it was disallowed. So we can assume that if they did get an opportunity to respond to the revised basis, that SARS wouldn't have allowed it. But we all can speculate. If they did have the opportunity and they substantially did it and convinced SARS on the first thesis, as the court felt it, there's in my view, a big possibility they could have convinced them on the second thesis as well. But we now sit with an assessment. They have paid a portion, and now we're going through the tax court process. So I think for me in future, it would be interesting to see whether the court still, this concept of a curative remedy, is it really not to the prejudice of taxpayers? In my view, a big prejudice to taxpayers is, that's our purpose of 42, is to prevent an assessment and avoid pay now, argue later, and all of that. So it would be interesting if the issue come across the courts again, whether that issue around pay now, argue later could influence a court differently. But anyway, let's see what happens.
Yeah, well, I think it begs the question then, why do we have Section 42? What is the purpose of it then? Because it cannot be enforced.
And as you said it, the court says UMK has a plausible case for review based on procedural unfairness. So what does that mean? And the court says, yes, it doesn't mean SARS is now carte blanche, because the risk is that if you do a response, SARS will just say, well, I'm not convinced, like they normally do, finalize it, issue an assessments. The court actually even says a grant, if you think SARS hasn't properly applied or considered your response, that also is a procedural ground of review. But now, it's going to be difficult to get a 105 direction there because of this concept of a so-called curative remedy. But anyway, we'll have to see what happens in future.
Then the court also didn't want to grant or didn't grant a 105 directive in the context of UMK's application for a declarator. It said that the meaning of control is quite complex, and that is not something that can be decided in a vacuum without reference to the applicable facts. Then in RAPA, RAPA raised, it was a review based on the merits and also on procedural non-compliance during the audit. But as I've said earlier, the real fight there was on its entitlement to the Rule 53 record. The High Court had compelled SARS to provide the Rule 53 record in the absence of a Section 105 direction. But as I've also said earlier, the Constitutional Court now confirmed that SARS is only compelled to provide that record if and when a 105 direction has been issued by the court. So the Constitutional Court said that it was not inclined to determine whether RAPA had made out a case for a 105 direction, and that if RAPA wishes to proceed with its review application, it can enroll it again in the High Court. Forge was the only applicant among the 5 cases who didn't receive leave to appeal. Its review was based on non-compliance with Section 42 of the Tax Administration Act, and also that SARS had introduced new matters in its Rule 31 statement in the tax court. It said that there was no compliance with Section 42 at all, since SARS, in essence, even though they said that they were conducting a verification, in essence, they were conducting an audit. The review was also brought late, outside the 180-day period as prescribed in PAJA. And the court said that there's no reason to interfere with the High Court's decision to refuse a 105 direction and also to refuse the period or to grant an extension for the review to have been brought. The court was also quite scathing as regards Forge's application. It said that a mundane and straightforward application tax case had been drawn out by I can't remember the exact word now, but by opportunistic review application. So I think that's an instance of where it went quite wrong.
I think Forge through the whole process, they were always late, and then they were in the High Court and then back in the tax court, and they were late throughout the process. Even the appeal to the CC was late and all of that. So I think the way that matter has been handled, unfortunately for the taxpayer, didn't count in their favor.
APSA's review was based on, it wanted to review ATJ notices, an assessment based on errors of law. So that's in the context.
That's the GAR provisions, right, Simon?
Provisions. Yes, yeah. That's correct. It said that SARS had made a party error and also a tax benefit error. It got a favorable decision by the High Court, but that was overturned by the Supreme Court of Appeal. The Constitutional Court said that the SCA was wrong to conclude that a 105 direction could be granted solely because it related to a point of law. Like I said earlier, the court said that even if it raises a pure point of law, the applicant needs to show something more. And in this case, the court said that the High Court should also have considered the risk of piecemeal litigation, because the party error and the tax benefit error are not the only grounds upon which APSA disputes these assessments that were raised by SARS. There are other grounds of attack as well. Ultimately, though, the court said that the High Court's decision to grant a 105 direction was not manifestly inappropriate, and that the SCA was wrong in finding that there were disputes of fact. So APSA, they will return to the Constitutional Court at a later date, will then decide the merits of APSA's review.
I think that's just quite important. So I think, as I said, I think APSA was a bit lucky based on this preemption issue. But I think not just for APSA, but I think for taxpayers generally, I think this is a good outcome, because now the Constitutional Court will pronounce on the interpretation of Section 80, particularly in relation to the tax benefit. What is meant by a tax benefit, and what is the party? Who must be the party in question? So I think this is a good outcome, and hopefully we'll get some good Constitutional Court case law to clear this thing up, because always when you do transactions, you obviously have to consider whether the GAR provisions can be used by SARS to attack your transaction. And, if the CC pronounce on the meaning and interpretation of those particular two aspects as part of the GAR provisions, I think it will be good law that could come from the Constitutional Court and provide some sort of more certainty for taxpayers as to how to interpret and apply those GAR provisions.
Yeah, definitely. Lewin, that, as we said earlier, that was an application for declaratory relief regarding zero rating of refined gold bars in terms of the VAT Act. As we also said, there was no assessment when that application was launched in the High Court. The Constitutional Court then confirms that a Section 105 was not required since there was no assessment yet. It further confirmed that the High Court had correctly entertained Lewin's application, and it found that the SCA's finding that there were disputes of fact didn't have any merit. Andries,
I think that's quite an interesting one. I obviously, as I mentioned, only Jars, our VAT partner, was involved. I sort of came late to the party to assist her at the stage when they appealed to the Supreme Court of Appeal. As mentioned, they lost. The High Court did entertain it on the merits, but the taxpayer lost it and they appealed to the SCA. Now, neither SARS or the taxpayer was concerned about Section 105. But, the court then said, the SCA sent a direction to the parties to say they don't see that the High Court has actually, in the judgment, given a direction on 105. So they invited additional supplementary heads on whether the SCA can entertain it in the circumstances where the High Court hasn't given a direction. And you'll see the SCA judgment as a minority judgment, which differed from the majority, which is also Judge Ponnen, which was the judge who written the judgments on RAPA and UMK1. But both of them then declined it on the basis, say there's issues of disputes of fact. And again, on the day, both SARS actually said 105 is not an issue and there's no dispute of fact. So unfortunately, both SARS and the taxpayer wanted clarity, and they wanted the direction, issue on the interpretation of that provision, because it is not just impacting Leeuwin, it's impacting all companies in the gold refining industry who actually, sell refined gold to APSA or to the Reserve Bank, etc., whether they can zero rate or not. So fortunately, sanity prevailed, and the court confirmed, their parties were at idem. It's a pure question of law. It's not to the benefit only of Leeuwin, but to similar taxpayers in Leeuwin position. So that's why they say it was right that the High Court did entertain it, and we're going to file heads. The court has asked us to file supplementary heads dealing with this issue, which we're going to file on Friday, and SARS, I think, in 2 weeks' time, and then they will set it down for hearing on this matter. So unfortunately, it has to go through the whole process, but I think the outcome of all of this is there's some clearer guidance on the application of Section 105, both in the reviews and declarators. So yeah, I think is this the last word? I think at least for me, as I said, we all know if there's an assessment, you must get the direction. And fortunately, the test is not exceptional circumstances. For me, that is the clear outcome. But yeah, I think you need to assess, as I said, as part of your dispute resolution planning and process, consider how you bring in alternative remedies in your process resolving those disputes, and when and how to use these, which could be quite useful tools.
Thanks, guys. I think that was super useful. And maybe just to kind of pull it together a little bit. So if you're thinking about your own matter and you're thinking, when is it appropriate to go for an alternative remedy? Let's just use the ABSA case because that's kind of the simplest version. So you out of the 5, so you get an assessment. In an ABSA's case, they got an assessment, and SARS said that they'd obtained a tax benefit and they were a party to a particular transaction. But what ABSA had done is they'd invested in a preference share issued by another entity, and the other entity had done a whole lot of transactions that SARS took issue with. So ABSA's case was simply, I'm not a party to those transactions. So you get the assessment, you say, I'm not a party to the transaction. Why should I have to go all the way to the tax court? Why can't I go and take this on review and get rid of this matter? And those are the kind of things or cases where alternative remedies are useful, because instead of taking 5 years and getting to the tax court at some point, you can go and have the High Court dispose of the matter. So I think that's kind of just to give a bit of context. And then in terms of this constitutional case, as you guys said, I think that really the key point for me is this test of exceptional circumstances that we all dislike so much has been replaced by this test of appropriateness or good cause. And I think that's a much more sort of reasonable, digestible test, to apply, as opposed to this very high bar of exceptional circumstances where nobody quite knows what it is. And then other useful things coming out of the case and the judgment were the internal remedy point. So again, if you're going for a review under PAJA and you get your assessment, then you need to object. Once you've objected, you have then followed your internal remedies, which is the requirement in Section 7 of PAJA, and SARS will then disallow your objection, and then you can apply for your 105 direction. So it's a very nice, clear piece of the judgment. So assessment, then you object, internal remedies, done and dealt. Remembering what you guys said for declarator, you're not under PAJA, so you don't need this internal remedy point, but you still need to think about, the High Court will still think about whether it's appropriate to give the direction. And then the other point for me, or 2 points, I suppose, is that you should think about, is the review going to be dispositive of the matter? And going back to the ABSA example, yes, it will be, because if the court finds that you're not a party to a transaction, then the whole assessment falls away. So that simple question of law, your assessment goes away, and you don't have to worry about the next 4 years. You can do other things in the next 4 years besides going to the tax court. And part of that is that it doesn't lead to piecemeal litigation. I suppose it is the same point, because if it's going to lead to piecemeal litigation, then from what you guys say, the High Court's not going to be too inclined to give you the direction. So I think those are kind of the sort of the key points for me. And Andries, towards the end as well, you said it needs to be a point of law. And I think just to emphasize that, because often, it's quite hard to work out what is a pure point of law, because facts are always important. We apply law to facts. So facts are important. And you might find that SARS attempted to say there is, in fact, there is a question of fact that's important, and that will be thrown at you. That will be, so that's coming.
That's the first offense. They say there's a dispute of fact.
There's a dispute of fact. Well, facts are important. We need to air those and ventilate those in a tax court, and witnesses and cross-examine. So get ready for that and make sure that it's really a pure point of law. But if all of those things are there, all of those ingredients are there, you can bake your cake and go to the High Court and go for declaratory relief or review relief. And I think it's a really, really important as you said, Andries, weapon to have in your tax dispute arsenal. So I thought that was super useful, and what we've seen, and you'd have heard the level of expertise coming in terms of this discussion. We've seen a big uptick in tax dispute work. We all know about the so-called tax gap between the amount of tax that's collected and the amount of tax that should be collected. And we're seeing a lot of disputes between taxpayers and SARS. It's a big focus. It's a big focus of our practice and of, I think, many practices. So we're going to be doing a seminar in June on tax disputes generally, and mapping out the process and what to do and what not to do, and providing guidance in respect of tax disputes generally. We're also going to be doing a webinar after that. So this is the first in kind of a series of interactions with you, our clients, in relation to tax dispute, the tax dispute area. As I said, it's only going to be ramped up. It's not going downwards, that's for sure. And it's a difficult, tricky area, as you'll have heard just from this discussion. I mean, this was just on one little point about how you can get into the High Court to have your review and declarator heard. So it is a minefield, and we're going to be interacting with you, our clients, over the next few months in various ways. So thank you very much for your attendance. This is being recorded, so it will be on our website, and you will be sent copies of the slides. There were some questions around that. And with that, Andries, Simon, thank you very much for your time and expertise, and thank you everyone for joining us, and we will speak again soon.
Thanks, everyone.
Cheers.
Cheers.
Thanks all. Cheers.